And the final bill on our calendar today is House Bill 1538, Karen's Law by Representative White. I will move the bill. It will be seconded by Senator Sabatina. I will also indicate to the members that Senator Sabatina's version of this bill passed the committee in March of 2019 unanimously, and by the full Senate in June of 2019. Both bills provide that the parole board need not hear an application for parole for individuals convicted of certain sexual crimes if the board already rendered a parole decision within the last 3 years. Currently, these applications may be made yearly. Senator Sabatina, would you like to speak about your bill, your companion bill, or this bill?
Yes, Madam Chair. Thank you very much. This bill is named after Karen Widdoss. Karen Widdoss was a constituent of mine who was brutally attacked and left for dead a number of years back. And her, I guess her, oh boy, she was the victim here, and her attacker basically applies for parole every year, forcing her to go back and relive this drastic crime that happened to her over and over again. And I think this goes a long way, protecting victims, protecting them from being re-victimized on an annual basis. And so I want to thank Chairwoman for running the bill, and I want to thank Martina White in the House for taking this up. And I want to thank Karen Widdoss and her mother for the tenacity they have in getting this bill passed. Thank you, everyone.
Thank you, Senator Sabatina, for your leadership on this issue. I do have an amendment. It is Amendment A05296. I will move the amendment, seconded by Senator Langerholk. This amendment does two important things. And first, it adds murder of the third degree and voluntary manslaughter to the list of offenses that would be subject to the 3-year limitation, both of which are classified felonies in the first degree. And the second piece of the amendment clarifies some confusion on an issue that was championed by families who felt powerless in the parole process, which led to the establishment of in-person victim testimony. I worked very closely with the family of the late Robert Curley, his sister Susan Grady, and her mom Mary Curley. And for them, the opportunity to be heard by the board was both empowering and necessary. As Senator Sabatina said, they felt powerless every year that this individual would come up for parole, that they had to meet with a hearing officer and not provide their own testimony. And for me, one of the most impactful things I've ever done is sit with the Curley family when they shared their story to members of the parole board. I thought that intent was clear when this legislation passed a number of years ago. However, it seems there's an interpretation to mean that they would have a choice of how to hear the testimony. And my amendment eliminates the doubt that has created, and it would require it to be in person. On the amendment A05296, are there any additional questions or comments? Are there any negative votes on the amendment? Seeing none, hearing none. On House Bill 1538 as amended, as you heard from Senator Sabatina, the namesake of the bill, Karen Widdoss, has agreed to the changes we've made. The District Attorneys Association is in support, as well as the victim advocate. Are there any negative votes on House Bill 1538 as amended? Seeing none, hearing none, the bill will advance out of committee. That concludes the business before the Senate Judiciary Committee, and I will recess to the call of the chair.